Stay here. हाथ में है उसको में पुश करो, ठीक है? जब हम ऐसे खड़ा करते हैं, पुश करते हो पीछे से तो गिर जाएगा आगे में। अब नहीं करता ना, इसलिए नहीं मांगी।
Any mention?
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 30.
30?
Yes.
Yes.
No objection, Your Lordship.
No urgency.
No, Lordship.
Yes.
The matter come up after vacation, Your Lordship.
Yes.
Obliged, Your Lordship.
Please, Lordship. Back to mention item 29, Lordship.
Subhashish Chandra Srivastava.
Lordship, this matter may come after vacation, Lordship.
No objection, Your Lordship.
Yes.
Obliged.
I please, Lordship. Lordship, I beg to mention item number 24, Lordship. Learned Senior Counsel is on leave, Lordship.
No objection, Your Lordship. Lordship, may the interim order continue?
After vacation, interim order to continue to further orders.
Lordship, similar prayer for item 28, Lordship.
Lordship, may this matter come next week, Your Lordship. There's been praying for adjournment.
After 1 week, yes.
Lordship, if it's possible on the 10th, Your Lordship.
You have no objection? No. Yes?
So if it's possible on the 10th, Your Lordship.
Why 10th? Auspicious day?
No, Your Lordship.
Okay. Next week we'll take a chances.
I'll oblige.
I'll oblige, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 32.
Number
Item 32.
32.
Your Lordship, the Correcting Council is out of station.
Whom is Linda?
Yes, Lordship.
My lord, I have an objection, but the difficulty here is that, my lord, since the affidavit has been filed, they have been adjourning this matter, my lord, for one or the other reason. And if lordship will have the affidavit of the state as well as I represent the private respondent, the petitioner has come with some document which have been in which he has fraudulently obtained the signatures of the job card holders. An inquiry was constituted in which it was found that 80% signature were found to be taken without the permission of the person. Their signature were misused, my lord.
Next week you tell.
So, my lord, this is very wrong, my lord.
Yes. Do on the prayers also, due to the absence of the High Council. This is matter, it's a fixed item next week. Yes.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 25. Lordship, I pray that this matter comes after vacation.
No objection, Lordship.
Lordship, similar prayer for item number 26.
Yes. Other side, who's there? 26. You're there.
I'm there, 26. Sir.
Yes.
May it please, Your Lordship, I beg to mention item number 21.
Here with Mr. Finon Nouri?
Yes, Your Lordship.
Yes. Yes.
Lordship.
After vacations.
Supplementary list, item number 1.
Yes.
My lord, my matter pertains to the non-communication of ACR, my lord. The petitioner is deprived from the promotion to the Suvidha GD, my lord. In this case, my lord, what happened? The petitioner approached before the Guwahati High Court, my lord, and the same was withdrawn on the jurisdiction issue, my lord. So we have filed this writ petition, my lord, and in the affidavit in opposition which filed by the respondent authority, they have admitted that the ACR has not been communicated to the petitioner, my lord.
Yeah, copy the affidavit. No.
No, everyone filed.
No,
Yeah,
they filed in Guwahati and yes.
That affidavit.
And then you've annexed the affidavit also?
yes, my lord. I have a next.
Okay, I heard Mr. V. Kumar. Yes, sir. Issue notice of Dr. N. Mozika. So on behalf of the Dr. N. Mozika is present with MS Emrichang. Now for the notice call upon the respondents list after vacations. Yes. Affidavit.
Item number 2.
Item 1 to 5 are connected.
Same orders.
No, my lord. Item number 2, my
Then,
lord.
why is your counsel MSP Chetri said same order from 1 to 5?
I'm sorry.
Oh, sorry.
Item number 2, my lord, the petitioner is discharged from service on medical ground and he is deprived from the disability lump sum compensation, my lord. My lord has issued the notice on the similar matter, my lord. That is writ petition number 435 of 2025.
Okay, yes, same order then. Yes, then she's correct.
Yes, my lord. 2 to 5.
2 to 5. Okay.
2 to 5 is similar. Yes, ma'am.
Oblige, your lordship.
Deep your lordship.
Daily list item number 1.
May please your lordship. Lordship, I'll be requiring some more time to file my rejoinder, my lord.
How many times you saw this movement?
This is the first time, my lord.
First time?
Yes, my lord.
Whose other side?
District Council. Respondent number 1 to 4.
Your name?
Alrintathiang. Miss Alrintathiang.
Your record, yes, Mr. Deji Mono. Who? MSTN Marak was whom?
My junior, my lord.
Yes, it's recorded wrong, last order. Oh, yes, okay, pretty yes. I don't know. Okay, no, it's fine. Yes, yes, AG1 praise funds allowed 2 weeks time to file the joinder.
Lordship. Hello, Lordship.
Just record. You record the presence.
Hello,
Item number
Lordship.
2.
Your Lordship,
Yes.
the conducting counsels in this post held you, so Your Lordship may kindly accommodate us for 2 weeks' time, Your Lordship.
2 weeks. 2 weeks will be out of vacation. Yes. Yeah.
Our hungry, Lordship.
Yes. So on a page submits that arguing counsel is in as arguing counsel in this court the matter be adjourned to after vacation. Prayers allowed. It's after vacation.
Item number 3.
Lordship, bring a week's time to file the objection.
Where's the petitioner? Yes, Mr. A. Khan. What about you? Mr. A. Khan for 1124 and MS Imran to send pray for allowed.
2 weeks' time.
2 weeks time to file objection to the review application.
Item number 4.
Yes, accordingly on. Yes. Yes.
Item number 4, my lord, contempt petition against the order dated 25/9/2024, my lord.
Yes.
For the cipher category, my lord.
Lordship, I'm praying some time to file affidavit.
And MACP.
Where Dr. Mojika?
Lordship, he's on next, Lordship. I'm praying for some time, Lordship, to file affidavit. We've not received parawise.
You not received the?
Parawise, Lordship.
Okay. Yes, after 2 weeks for affidavit.
5.
My lord.
On the prayer also 2 weeks for the 2 weeks time. Yeah.
Your Lordship, they've complied, Your Lordship, with your order. This matter may be closed, Your Lordship.
Yes, as I reported, the order has been complied. The initial petition stands closed. The contempt applications upon stands closed.
6. May it please your Lordship. Lordship, in this matter, we're supposed to file supplementary affidavit.
Who's who filed this? The union?
Union, Lordship.
Then?
Lordship, we've been told that the Ministry of Personal and Public Grievances have referred the matter to the Ministry of Tribal Affairs. So we require some time, Lordship, to
What is this matter about?
Reservation, Your Lordship.
Reservation, the State Bank?
SBI Bank.
Reservation for scheduled tribes. State Bank.
MSM Risang submits that as a matter under consideration by the concerned ministry for the time we required to file supplementary affidavit. Yes, yes.
After 2 weeks.
She prays funds allowed. further 2 weeks to file the same. Yes.
7.
On phone, yes.
7.
My lord. My lord, I'm for respondent number 2219, Steel Authority of India Limited. There is nothing in this matter, my lord. First they wanted to file a rejoinder, they did not.
I have instructions, my lord, that there are some talks going on.
You withdraw it.
No,
You withdraw it if you have fresh cause action. You file it.
Let this matter be taken up next week, lordship.
My lord,
We'll
there
come with concrete instructions.
There are no
lordship.
talks going on, my lord. I have confirmed.
That is what my
No
instruction
talk going on.
No talks, my lord. My lord, my counter affidavits, page 136.
Lordship, let it be
Clause
taken up next week,
23,
lordship.
my
If
lord.
nothing comes out concrete, then we'll have the matter fixed for
My
hearing,
lord.
lordship.
Page 136 affidavit.
My lord. Clause 23, my lord. 136, my lord.
Clause 23.
23, my lord. My lord, for domestic contracts where supplier service provider is an Indian party, which they are, my lord, in the event of any dispute arising out of or in connection with the contract in question which has not been resolved through conciliation in accordance with the procedure laid down in clause above, the aggrieved party may invoke arbitration.
Have you written a letter to invoke arbitration?
My lord, they have gone, since they are an MSME,
Yes.
so they will be following the procedure which is contained inside MSME, which is a self-contained code. They have approached the MSME Facilitation Council, my lord.
Then what's happened after that?
So first when they withdrew, again they have filed it afresh. So my lord, the arbitration proceeding will be initiated through the MSME, the Institute of MSME, my lord. So there is nothing which survives in this writ, my lord.
Lordship, fix it after a week, lordship. We'll have instructions taken regarding the appointment of arbitrator, lordship.
And my lord, exactly similar matter had cropped up earlier, my lord. Division bench has already given a judgment, my lord, in Pioneer Carbide, my lord, where there was an arbitration clause. Sale was a party.
That was outside the
that please
sale
go,
agreement,
since
lordship.
there is an arbitration clause, the court said we will not exercise any writ jurisdiction, my lord, and they were directed to go for the arbitration proceedings.
Yes. Yes, you went against a single bench order.
Lordship.
My lord.
Yes.
Lordship. So that was not within the contract agreement.
And the
lordship. It
division
was
bench
outside
upheld
the
it,
domain
my
of the agreement, lordship.
My lord, para 4 of that particular judgment from the division bench says, my lord, as far as the present case is concerned, the proposed matrix contract contains a clause for conciliation between the parties, and upon the conciliation failing, for disputes to be carried to arbitration. My lord, the same clause which I have read out for a contract agreement which is executed between me and them.
See, your simple dispute is you ask supply, you couldn't supply. That's it.
Lordship.
So that's the only thing. Then what is that? How can we interfere now in writ proceedings? How do we see that order is
And this is,
violated
lordship,
your
what I
rights?
am praying is, lordship, may have it next week, lordship. We'll have
Next week, your
instructions
senior
taken.
won't argue also.
Lordship, he is here, lordship. He'll be there, lordship.
He's not. I mean, it's too many matters.
Lordship. Next week, lordship, we'll have instructions taken, lordship.
My lord, there is nothing which survives in this
What's
case.
the matter in terms of the division bench order?
Lordship, let him be disposed in
And
his
my lord,
presence,
we are ready for them to come for arbitration, because we also acknowledge a dispute.
Raised vehement objections with regard to keeping the petition pending in view of the fact alternate remedies available as per the agreement entered into between the petitioner and the respondent. Respondent number
2219, my lord.
219.
Clause 23, my lord, of the contract act.
Learned counsel referred specifically to clause 23 of the agreement which provides for arbitration.
My lord, it is the clause 23 of the GCC.
Further submitted that the company being governed by MSME regulations or scheme, the same is self-contained. This guidelines are contained therein for resolution of such disputes. Ms. S. Chanda, however, expresses his helplessness in the absence of a senior lists next week, yes. It's understood next date the matter will be disposed of in terms of the division bench order of this court passed in appeal number 9/2022 by order of this court dated 26/5/2022 passed in appeal number 9/2022. Yes.
Obliged, my lord.
Item number 8.
My lord, in this matter, my lord, we have not received any pension as of now yet, my lord.
Your Lordship, is from CDA. I didn't get any instruction at the moment. Maybe in the next week, Your Lordship. The officer earlier he was posted in another place, another person is there.
My lord, here the dependent.
It is unfortunate that till date the what is this family pension
Yes, my lord.
to the deceased employee's handicap. He's mentally challenged, right?
Yes, mentally challenged.
Son is yet to be released. So, release the matter on Monday for final orders.
Highly obliged, my lord.
9.
Better get it released, otherwise. Yes.
State has filed the affidavit.
Yes.
Yes, Your Lordship. We will file the rejoinder, Lordship.
Yes. Mr. Kivarji submits that affidavit we have the response has been filed. MS EB Pass, however, prays for 1 week further 1 week stand file after praise allowed. Stop petitioner may file rejoinder to state after respondents. So the after state respondent meanwhile is
10.
Your Lordship, I'm praying that this matter may come up at the end of the board, Your Lordship.
yes.
Lordship, let it come after vacation, Lordship.
Yes.
Your Lordship,
Yes,
at the end of the board, Your Lordship.
Enough of adjournments of your cases. Yes, on the prayer of MS Emmerich, let's matter after.
Lordship, after a week, Your Lordship.
It's
a small issue.
Small matter, but then he should be ready to argue it.
11.
Yes. The court can't bend over backwards to just accommodate all requests. Yes.
May it please, Lordship.
Yes.
Lordship, here the respondents are yet to file affidavits.
My lord, I crave your kind indulgence, my lord. Can you grant me some time, my lord? We have received all the.
So can you see, Lordship, how many times they have sought time?
And
How many
my lord,
times is the
More than 5 times, Lordship.
More than 5 times. What's the matter about?
This is regarding that impugned order passed in a reference application filed by the petitioners. Lordship. It's
As per
a
my
simple
instruction,
issue, Lordship.
Lordship, no, my lord. I have soft copy, my lord. It's from Garvas. In fact, my lord, you don't have the locus, my lord. They have no
Put down affidavit. Will
Can you grant me 2 weeks time, my
They're
lord?
supposed to
How
file
when
the
did you get
affidavit,
instruction?
Lordship, I have received the annexes yesterday, my lord, through soft copy.
Okay, Mr. J. Ranja submits that as he's just received the instructions, he may be allowed 2 weeks time for affidavit. Prayers allowed.
Deeply.
Yes, after 2
Lord.
weeks.
12.
Please, Your Lordship, we need some time to file our affidavit. We received instructions.
For that time. Yes. I'm also paying some time to file. Any urgency? No urgency. Yes, MS T. Yangi B. Let it AAG with Mr. Jendranja for respondent 1, 2, 3. Marak for number 4, Mr. Marak. You will file affidavit. Mr. Amara for 4 and Mr.
5 and 6.
Yes, for 5 and 6. Pray for allowed for the 2 weeks time to file affidavit. This thereafter. And so and so.
13.
Yes.
Please, Your Lordship, I'll be filing my rejoinder affidavit in the course of the day, Lordship.
Will posted for hearing.
Lordship, yes.
MS E.D. Cruz submits that the rejoinder will find the course of the day. It's a matter of application for.
Lordships, if I may pray, if this matter may come up next week, we
Why?
can
What's the
dispose of the
urgency?
matter, Lordship. It's on a very small issue, Lordship.
What's the issue?
Lordship, this is a transgender matter where reservation was sought for in the Indian
See, the
Institute
thing
of
is,
Management.
the simple thing is that they don't have any provision for transgenders
Lordship.
reservation. So
Lordship, sir, there is an aspect where I'd like to.
The thing is that
convince
let them you file the rejoinder, let them examine it, we'll have amplification.
Lordship.
Yes.
Highly obliged, Lordship.
14.
Lord, this matter we have settled, and the challenge has been led to your Lordship's order before the writ appeal, my Lord. There we have arrived at some settlement, my Lord, and the writ appeal has been adjourned for filing of the settlement.
You have settled the matter?
Has settled the matter to the extent of principal. There was about 60 crore rupees was the principal and 60 crore was interest. So on principal.
You mean the Mrs. case save your skin?
Yes, my lord. Then the writ appeal we will pray for disposal of entire matter, and they have also settled. Also, we have
you will close the matter here.
Your lordship. Then writ appeal will become infructuous, your lordship, because it is arising out of the interim order.
Then if you settled it, the writ petition is pending. Writ appeal becomes infructuous after you place a settlement before where the main cause of action arises when you file the matter.
Yes, my lord. Your lordship, I would pray that your lordship may have it on 15th of this month. 15th, by the time we will also, because we have made the statement in appellate forum, my lord, in writ appeal, that we have settled the matter, and for filing of settlement matter is adjourned for 10th of this month, my lord.
Okay. Yes, Legal Advocate General, on behalf of the respondents, submits a matter since been settled.
Yes, sir.
Yes, to a certain extent.
Petitioner, I am sorry, my lord. We are
Yes,
yes, submits a matter settled to a certain extent. It seems not disputed by the counsel for the respondent. That view, the matter, it's further submitted that the writ appeal had also been preferred against the order dated. What is the order dated?
The order was, your lordship's order was.
Order dated. I can miss case. Disposed of miss case. Order. 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 Order pass. Come on. The order table is put into the appeal together.
What is the date of the order? Nobody carries the file. I don't know why. The most important thing is file.
Order the? I don't know. Where is the appeal order? Probably appeal the.
11th November, my lord.
It was disposed.
In this case, number?
It was passed in this case number.
Thought no. And also against the dated 11th November 2025 passed in. Huh?
Miss case number.
W869.
No, not there.
Yes.
What is miss case number?
If I may, miss case 261 of 2025.
Miss case, you sure about the miss case number?
Yes, Your Honor, it's saying from the CIS.
261
of 2025.
Arising out of the incident writ petition. So according to this matter, and the settlement agreement will be also presented before the division bench.
Your Lordship, I just have a humble request. If Your Lordship just would mention that the settlement has just been done on the principal amount, if that could be just reflected in
I said to a certain extent. I'm not saying principal amount, or I just said to a certain extent. That's what about it. That yes, this certification. Or list before closing.
Yes, and your lordship may have it on 12th, my lord. 11th.
So this on 12.
MC WPC 261 of 2025.
What do you come down with on?
And you have to receive there.
Somebody can tell them.
13th, your lordship, 13th. 15th, your lordship. Lordship may 15th.
15.
Even even decided to get there, we decided to. Group section with Huh?
Very difficult matter.
Just pass it to the side.
Yes, Mr. Shilla.
Yes, my lord. By way of this petition, my lord, we are bringing to the notice of this honorable court the endorsement of a case.
No, has been notified or not? This new. Not been notified, correct?
Not been notified, my lord. Because the.
Let it be, Mr. Shilla, since they're wearing the same hat.
No, my lord.
They're wearing a different hat only, the same person.
My lord, I'll just.
And Mr.
We understand.
I understand, my lord.
We understand on procedure and also on you know, what do you call it? Nomenclature. Yes.
My lord, I'll just like to
research has been done by Mr.
Yes. What is this?
This is a brief chart, my lord, regarding the civil laws that is applicable in Meghalaya, my lord. Like in normal Shillong, my lord, before the state of Meghalaya attained statehood, we have the Shillong Civil Codes Act 1947, in particular Section 3 and the first schedule of that act. It applied the Bengal, Agra and Assam Civil Code Act 1887. So thereafter, my lord, after we attained statehood, the Meghalaya Adaptation of Law Orders 1974, in particular paragraph 3 and the first schedule, applied the Bengal, Agra and Assam Civil Code Act 1887. My lord, through this act, the courts has been constituted. The three courts that have been constituted, my lord, you will see that there's a court of district judge, court of additional judge, court of subordinate judge and court of mansif. Chapter 3 of that act, my lord, defines the jurisdiction of the court as well as the provisions for appeal, so on and so forth, my lord.
Yes.
My lord, in other parts of Meghalaya, like in Khas Hills and Jaintia Hills, other than normal Shillong, my lord, we have the 1937 rules before the coming of this, before our statehood, my lord. In addition to that, my lord, I have not noted down there, but my lord is well aware that there's the Khasi's Aimship Administration of Justice Order 1950 also. So after that, my lord, after we attained statehood, my lord, the Meghalaya Adaptation of Laws Order Act number 1, 1973, my lord, it applied this Administration of Justice and Police Khasi and Jaintia Rules 1937, as well as the order of the Aimship orders, my lord. There also, my lord, it defines, it constitutes the code and it defines its power. So, my lord, subsequently in Garo Hills also similar situation, 1937 rules, my lord.
Yeah.
So now the question is this, my lord, how did this civil judge senior division came to existence?
Yes.
So now, my lord, after doing a bit of research, my lord, we came to, I came across this.
Judicial Service Amendment.
Yes, my lord, 2023, my lord. This, my lord, in its schedule, my lord, it has created this post of civil judge senior division. It was clarified by way of corrigendum, my lord, because initially it was mentioned only civil judge, but corrigendum came to being and it was clarified it's civil judge senior division, my lord.
Yeah.
Thereafter, my lord, it was reiterated by the notification issued by Registrar General of the High Court that in view of one judgment of Honorable Supreme Court Honorable Supreme Court, my lord, where it says that there has to be uniform judiciary, uniform designation all over India. That was for the purpose of pay, my lord. So that's why this particular post was created. But my lord will appreciate that this Meghalaya Judicial Service Rule.
No, I mean, no, what you're saying that there's no conferment of powers.
Exactly, my lord.
That's all.
That's
so
all, my lord.
You see, there's no conferment of powers as civil judge.
My friend is,
but the thing is that doesn't mean that they exercise the same jurisdiction. Simple as that.
But that has to be defined.
We are governed by 37
if
rules.
I have understood my friend correctly.
See, what Mr. Shilla is saying, if I also understand correctly, is that unless there's a proper conferment of powers, and as
under the act,
and to bring that nomenclature, to correct the nomenclature of all judicial officers, because in all other parts of the country, we don't have nuances, we don't have litigators, we have civil judge senior division, civil judge junior division. So those are the things. So the order of Supreme Court says to rationalize the
the post.
So across the country, when they prescribe pay scale also for states to adopt, so you'll know instead of saying like in state so and so there's some other post known as this.
Uniformity is to
uniformity. So the purpose of this uniformity. But what he's agreed with is that before these sort of powers have been conferred, or designation has been conferred on a particular judge, now in the particular jurisdiction wherever he's agreed with, the district sessions judge there, has endorsed a file by saying to the
senior judge,
civil judge, senior division.
That's the only thing.
So, if I have understood correctly, my friend is saying that there is no act which has by which these courts have been created.
Creation is not a problem, but conferment of powers.
Conferment of powers.
You have to define the jurisdiction.
Suppose now you take the judgment of Supreme Court, and you take
so therefore, kindly see three provisions of the Constitution. Only 3 articles. Article 233. Yes, Article 233, my lord.
Okay.
Article 233 says, my lord, appointment of persons to be and the posting and promotion of district judge and in any state shall be made by the governor of the state in consultation with the High Court, exercising jurisdiction in relation to such state. So the appointment is to be made by the governor in consultation with the High Court. And district judge has been defined, my lord, if your lordship will, in 236. In the chapter, the expression district judge includes judge of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of small court, chief presidency magistrate, additional chief presidency, session judge, additional judge. So therefore, my lord, my submission is that under these my friend has cited the provisions which are pre-constitutional. Now, under Article 233, district judges have been created, and district judges have been treated as equivalent to the city civil judge, various additional district judges. So now we have the district judiciary in terms of the constitutional provision, my lord. In terms of the constitutional provision, deriving power from that, the High Court has framed the rules whereby it has created various senior court. So those courts are in existence, my lord. By virtue of
that existence, courts are in existence.
Now the question:
what designation and conferment of powers you have to give as per the amendments?
Now the question is, my lord, why do we need amendment? Because when we have created the code and CPC has been extended and power of the power to be exercised by senior,
you have to issue a clarificatory notification conferring power. You have to do that because then it'll be across the board.
Yes, Lord. You may have it after. I understand.
In one district, you endorse the case. You take up the matter as additional to deputy commissioner. Then you endorse it to the assistant. Another court take it as a civil judge. Then you endorse it. I mean,
But if we can extend the
district sessions,
we extend the act also to the other parts of Meghalaya. That anomaly can be.
Uniformity, it should be instead of simplifying, rationalizing the issue is complicating it.
Yes, my lord. We will take it after vacation.
Actually, just a correction. I'm referring to the private respondent.
Yes.
Number 3. May I just show something? It just caught my attention. Please see the compilation that my friend for the petitioner has served.
Yes.
Number G.
G.
This is the original notification amending the rules.
Yes.
Notification date 13 September 2023. Something very interesting because I was curious about this. We have junior division and senior division.
Yes.
But we don't know their pecuniary limits. Now please see Schedule A in the next page. If you lordship look at grade 1, there is district judge, sessions judge, additional district judge, additional session judge, member MSAT, special judge, NDPS, special judge.
Yes.
So please see grade 2.
Yes.
Civil judge, chief judicial magistrate, assistant district and session judge.
Yes.
Now if your lordships look at H, serial number H, which is flag mark, the flag mark H. This is a corrigendum dated 25th October 23.
Sorry.
Yes. Civil division, yes.
Civil judge, which is a grade 2 post, should be read. So senior judge.
So there's some discrepancy here also. That means the matter should have gone to the assistant deputy commissioner.
Yes, to grade 2.
Yes. No, it should go to grade 3.
Yes.
It should go to grade 3, it's gone to grade 2.
Grade 2. No, the appeal. I have preferred an appeal. My appeal is
going to grade 2.
Yes, my appeal is going to grade 2.
Okay.
Senior division. So this is a serious complication.
We'll try to resolve it.
Yes, yes.
Because they need a clarification.
Yes,
This
yes,
is my understanding. I may be wrong, but that's my understanding is that if you can rationalize, it should be across the board.
Across
proper
the board,
notification.
all.
Perhaps
It's not a question of creating new posts, it's not creating new posts or putting new officers or creating new jurisdictions. It's just how you classify them.
Yes, yes.
It'll be easier for all the lawyers. Also.
Yes, yes. Because I think this same problem is there in Nopal, so everywhere.
It'll be everywhere. Yes, Learned Advocate General has praised that as the matter deserves more detailed consideration by the state government. Further, how much time?
4 weeks.
4 weeks time be allowed for affidavit. Praise Lord, yes.
16.
And in fact, it's a very small issue. It's not a big problem.
We'll try to resolve before the next.
And this is not an adversarial.
No, it is not adversarial.
No, the thing is that see,
But this,
as it is, this the administrative justice system here, it's very complicated.
Yes,
so people outside, and so even for the people in law department, it's very difficult to.
Yes, yes,
even practitioners here, I think.
Yes, yes, yes. And we don't want to be that situation of criminal justice, my lord. Kamarchan came to be and all. Otherwise, we will also be the civil case. Oblige, my lord.
16.
16, Your Lordship, we need some time to file our affidavit. We've received instructions, Your Lordship.
Yes. No. I have wait for the 2 weeks time allowed for affidavit. That's it.
17.
May it please your lordship. I'm praying for some time to file our affidavit, lordship.
Who's Mr.
That's the conducting counsel from Guwahati. I'm the local counsel.
Yes, Mr. S. Marpan. Sorry, MS Emmerichan. Yes, for response praise for the Lord for the 2 weeks time.
3 weeks time, lordship. Is it
2 weeks time. 3 weeks time. 2 weeks also will go after vacation.
18.
Yes.
Please, my lords. My lords, I directed my learned friend to seek instructions and place it before my lords regarding my lords, the number of cases that was passed by order dated 14/11. Matter thereafter came up on 21/11, where my learned friend again took time.
Lordship, we file our objection to the writ petition, Lordship. But in the meanwhile, my lord, there are 8 cases pending, my lord.
Across the state?
Lordship.
In 8 jurisdictions?
4 jurisdictions, Lordship.
Can you give it in a form of
That's what was.
My lord, because we are filing our objection to the writ, my lord.
Today?
No, we've already filed last date, Lordship.
No, where you given the cases?
The number of cases is here with me.
You give it the.
No, my lord, it's with me right now.
Let me see it. Let's put it. Why you want to withhold
No,
it?
because we filed our objection, Lordship. So
No. What have you been with that submission? Have you included this in your?
we just
objection?
received it yesterday, Lordship.
This has not been filed. Well, this entire matter can be closed if they just bring it out by way of a affidavit. My lords, matter can be
And
closed.
this is all within their knowledge, Lordship.
That we don't know. Within the knowledge or without the knowledge. Charge sheeted with Garo Hills. All are pending investigations. The rest 7 cases. Most on Buck and Reboy.
Lordship.
Where's your objection?
It's on both, my lord.
Objection, my lords, is on the issue of alternative remedy, my lords. I think this was filed by them on the 21st of November.
It hadn't come up after that.
It came up, my lords. The matter came up on the 21st of November itself. That is the day on which they filed the objections.
What objection is this?
So, as regards the maintainability of the matter, that's what my learned friend has filed.
This is what we have raised right from the date of motion, Lordship.
No,
That's
no,
not
what
making.
you're just citing cases.
That's what is, my lords.
What we are saying is that they could have approached the concerned authorities instead of coming by way of a writ, my lord.
No, see, when a person comes by way of writ, it's they are alleging harassment, that there are multiple FIRs been filed against them throughout the state, which is not aware. So when they go to appear before the police station, they are slapped with fresh additional charges, and that is the problem. So that if it causes harassment to a citizen, might be no one is guilty until proven innocent. So any innocent deserves a fair deal. Any citizen.
If I may, my lord.
Every citizen who goes, and then yes, they have recourse altered remedy. But if the manner adopted is so with prima facie, it shows that it's all over the state. FIRs are being filed, so they have a right to come to say they consolidate whatever do you have under one jurisdiction, so they can face in time with the trial or whatever.
One place.
But my lord, to say that fresh charges are slapped against them when they go appear
Where have you? That's what I want to see an objection where you said that is not true. But that's what I was exactly.
We objected to writ, lordship.
But the thing is that their allegation is that when they appeared in Khanapara, that a POCSO.
After I cooperated with the investigation, the Khanapara police station, then Tura women PS comes in.
During investigation, the accused person would call up one of the ladies. That's why POCSO was slapped against him. But my lord,
it is on the basis of a phone call.
These are not fresh allegations, my lord.
I'm bemused, my lords, that the government of Meghalaya is actually registering a POCSO case on the basis of a phone call.
At the bemusement of the counsel for the petitioner, my lord.
Yes.
These are all fresh cases, lordship. I mean, like all cases. No fresh cases were slapped when they went to appear before the concerned IO.
One is case 2025. This is 25.
I would only pray, let this come by way of whatever, and your lordship can then close this matter, and then I can follow my appropriate remedy.
One thing, you give him a list, we'll close it. He'll pursue other remedies.
That's what my prayer has been from the first place.
MSNG Shilla Leonard, a senior advocate today, has produced a list showing the number of cases and generally pending against writ petition in various jurisdictions. So, the same is produced by the court. A copy will be made over to the counsel petitioner.
I have not got it as yet.
We'll make over. We'll sort this information. Stop. As this availability altered remedy, the petitioner is given the liberty to seek altered relief as permissible. Yes. You give him a list.
What I'm praying is your lordships may just record and make this part of the record. So then
the same
it gets frozen.
The same record. Yes. You supply him a list.
Then I'm given a granted liberty to approach appropriate jurisdiction. That was my prayer in the first place.
Against you.
Their prayer was to appear by VC, my lord. Much obliged, lordship.
No, I did not press for any of those. This matter will then stand closed. Highly obliged.
Please, your lordship. Your lordship, I'm appearing for respondent.
You're a counsel for the council now.
Yes, your lordship. Enter again.
Yes.
Your lordship, the matter is fixed today for consideration of interim prayer, your lordship.
Interim prayer for?
Your lordship.
Your lordship.
How much can you pay them?
Your lordship, I'll have to take instruction because the last order that was given was 24th October 2024, your
The first payment was given to them.
No,
last payment.
First payment was given in 23 of December. And second payment was made on last year, your lordship, October 2024. Then after that, no payment. We have made representations, your lordship. We have even met the respondent for. He has assured us that payments will be made after the budget session. Your lordship, if you would come to page 105 of the petition, your lordship.
No, see 2410, how much all the petitions were paid.
Your lordship.
Whereas segregation among some petitions paid and some not paid.
No, your lordship. Your lordship.
Allegation is there.
Some allegation is there. Your lordship, with regard to the other ex-members.
Other ex-members have been paid. They have discriminated against you.
Your lordship. Your lordship, that will be at page 67, your lordship. 67.
Why discriminated against them?
We have filed
I'll have to take instruction. I've just been endorsed with the file, your lordship.
You pay all of them.
Your lordship.
If you pay one, they all equally entitled, correct?
Your lordship, similarly placed. Your lordship, it was during the same year during the first round of litigation, where the respondent councils had made a submission before this court that they have no funds. And in that same year, your lordship, they paid 6 lakhs to other ex-members. And your lordship, there's a budget also which is passed regard to the
Yes,
pension.
so the matter is fixed today for consideration of interim prayer for release of some payment to the petitioners. Stop MS PS Nongri appearing for the all respondents.
All respondent, 1 to 4, your lordship.
Submits that she has just been endorsed of the file and requires some time to obtain
Instructions, your lordship.
proper instructions. Yes. So you have
Lordship,
to.
after a week, your lordship, it's been a year that they have not been paid, your lordship. And your lordship, the respondents, they have, your lordship, funds on the basis of the budget passed in this year, July 2025.
We take after a week. Christmas is coming. Yes. They need the pension. Yes.
Highly obliged.
Just after 1 week. Yes.
Lordship, my apologies. I beg to mention item number 31, Lordship.
For what?
Lordship, if this matter can be taken.
Bench is sitting again. Just breaking for 10 minutes. Yes. We take a tea recess. Yes.
20.
May it please your lordship.
Yes.
Lordship, in this matter, we have filed the affidavit, your lordship.
Your Lordship, I would like to file reply to this counter.
Lordship, I don't have the objection to that filing of reply because the admitted fact, your lordship, the chairman and the secretary of the BSc, they cannot hold the post respectively in view of the fact that they are teacher in the
Is that correct? You're a teacher?
Lordship,
The
kindly
secretary, she is not a teacher, Lordship.
Lordship, kindly have
The chairman might be a teacher, Lordship, but then the secretary,
kindly have
she is not a teacher.
para 8 at page 2 of our affidavit, your lordship.
So I would like to bring into record also, Lordship.
Yes, 1 second.
And lordship, kindly
Para 8,
your lordship.
Page
2, your lordship.
Both are teachers, Najulong.
Lordship,
No,
yes.
Lordship, only
Lordship,
the
kindly
chairman
have
might be a teacher, but
page
then the
7,
secretary
page
is not.
7 of the that is the notification issued by the government.
And they haven't bring anything in record also showing that I am a teacher, Your Lordship.
Lordship, kindly
Yes,
see.
no government SSA,
Here, right,
government
no government SSA, government aided school teachers shall be allowed to function as secretary president in the state of Meghalaya.
So, you better withdraw your petition.
Lordship, I will file a reply, Lordship.
No
And-
reply.
Yes, Lordship, I would like to bring into record, Lordship, since the secretary, she is not a teacher, Lordship. And they have not even annexed any documents to support the statement, Lordship.
Where's the imprint order?
Lordship, the vernacular at page 66 and the translated copy at page 67.
Your stand is that while the old VEC is still functioning,
Yes,
without
Lordship.
notice to you, they are going to reconstitute the new VEC.
New
correct?
VSC, Lordship.
Now, if their contention is correct, that both of you are teachers,
No, Lordship, it is not
then
correct, Lordship.
when's the VEC election fixed? It was stayed.
That has been stated, Your Lordship. In fact, there was a BC election on 5/9. On 5/9, election was already held, Your Lordship, and they lodged a complaint against the BDO. Your
Okay.
Lordship.
An affidavit has been filed by the state respondents stating that the petitioners are teachers in aided school.
Lordship, yes.
Aided school stop, which disqualifies
Lordship,
them.
we have stated Light Lulong, Roman
disqualifies them.
Catholic, Lower Primary
Yes,
School,
1
SSE
second.
Soyong.
Aided school? In which school?
Light Lulong, RCLP School, SSE Soyong.
At Light Lulong
RCLP School,
RCLP School, SSA,
SSA, Soyong.
Soyong, East Coast District. Thọ Shua Kata? Tahu no? No, Udil Shua Kata. Both the red petitioners are teachers in Light Ulong RCLP School, SSA Soyong East Khasis District, which would disqualify them from holding any office of secretary or president of the VEC, this State of Meghalaya. MS Khasamlang, therefore placed without required objection. This is matter on Tuesday as a fixed matter for instructions.
Lordship, there are some annexes which are missing also in this counter.
Doesn't matter on Tuesday instructions whether teachers or not. Otherwise, would we have heavy cost?
Yes, Lordship.
Yes, on Tuesday.
Interim order may be continued,
on the
Lordship.
9th.
Interim order may be continued,
We
Lordship.
continue till Tuesday. Yes, on 9th as a fixed matter. Yes.
Hearing 22.
Apply, Your Lord.
Yes.
May it pray, Your Lordship. The prayer Your Lordship has seen on the last date of hearing is only for direction to consider the representation, my Lord. Page 28, 29, my Lord.
This is which matter is this?
Well, as this pertains to the CDPOs,
28, 29.
under the Social Welfare Department, well, it's very limited issue involved.
One
So,
second.
Your Lordship, kindly see prayer 28, 29. So, Your Lordship may
13.
not be required to be gone into. We will decide the representation. Matter can be disposed of, my Lord.
So, well, it's what I am not in disagreement with my learned friend.
28, 29, Your Lordship, kindly see prayer. 29, Your Lord.
Yes.
Well, it's the only issue here is that if they consider it, my lords, and dispose it of, now the counter affidavit which they've come, they're not really disputing our position. Only thing they say, my lords, is that from time to time the government has been, my lords, the file has been going from one side to the other.
So give
For the
them a
purposes
time frame.
within a time frame, my lords, they should do the needful, because the last position that they say as per the counter affidavit, I'll just point it out, my lords.
Lordship may ignore the counter affidavit, my Lord. Your Lordship, I am saying Lordship ignore the
What
counter
objection is this to the impleadment application you filed?
Well, it's impleadment. These are people, my lords, who wanted to implead themselves in this matter. They say, my lords, they are in that select list.
order which was going on, which
They were,
was coming.
if I may just finish.
Yes.
Well, as if my lords are disposing of the main matter, there is no requirement of them being impleaded. That's one part of it. The other part of it is, my lords, we are saying that merely because your name appears on a select list, that would not give you a right to
That
get.
is a different independent issue, my Lord.
That's exactly. So what I'm submitting here before my lords is that if the position of the government is, my lords, is that they are otherwise agreeable to this, because our
representation.
No, just
agreeable to this extent.
no. I'm going on what is on record. I think my friend is a.
What have they said in the affidavit?
I'll take your lordships on this.
Yes.
They have not. They said they will.
They said they have disposed.
Just wait a second. Wait. Which paragraph?
This one. And the amendment is under processing.
Yes. Well, if I may draw your lordship's attention, from para 16 onwards, well, it's
16 onwards.
Para 15 onwards. They've actually enumerated, my lords, what steps has the government taken. That the dependent states that letter number so and so dated 1st December 2021. The
So you
director.
mean to say they have not been amended as yet?
Well, they say it is in the process of being amended.
My Lord, we have got the recruitment rules, my Lord. 2007 recruitment rules.
No. What about this?
The counter affidavit talks about the correspondences between directorate and the government, my Lord. Ultimately, whether we have the amended rule or unamended rule, it is the prerogative of the policy of the government. They are concerned with the policy. They are concerned with the disposal of representation.
I am saying, well,
they are not questioning the policy. Also,
I am not questioning the policy, because the policy is in my favor. Because the government does not, directly say that they are not considering this. They say that they have agreed to the initial appointment being made on a 50-50 basis. 50% through direct recruitment, 50% through promotion. That was the limited case, because these people are all in service. We were called for consultation. On the basis of the consultation, it was decided that this should be the manner in which it should be done. Now, pursuant to that, my lords, this kind of correspondence is there on record before my lords, where they say that they're actually in the process of doing it.
No, so you say 15-16 indicates that.
Well, it's not only 15-16, well, it's furthermore, my lords.
We will decide the matter finally.
If your lordships kindly have a look at para 20, that the dependent humbly submits that the government submitted the draft amended service rules to the personal department, which in turn directed to make necessary corrections and resubmit by its so and so. That's again been done, my lords.
It's an internet departmental correspondence they are referring to.
No.
Nothing, my Lord.
No, nothing.
Nothing. These
I'm
are
sorry,
all
Millet.
internal departmental correspondence. They can't do.
We can't ignore them also. If they also, it's a process.
See, ultimately, my Lord, it is a decision which is important.
Of course.
Internal departmental correspondence may take place on 20 points, but ultimately decision is the final thing, which will be tested before your lordship, whether that decision is correct or as per government policy or not. And their whole in limited case before your lordship is to decide their representation, which we are willing to do that.
That's what had been submitted before my lords on the last occasion, if I remember correctly, was that
neither here nor there. Submissions, so they want to build their case on submissions.
It's okay, no. Yes, what were you submitting?
My lords, what my learned friend is trying to suggest is, are we before a kangaroo court? With all due respect, my
Do I
lords.
look like a kangaroo?
Absolutely not.
Yes, we are.
With what is being submitted, what is being submitted before my lords, what is being submitted before my lords is that statements can be made left, right, and center without any gravity.
Prayer can be made for prayer.
Any submissions can be made. It's for the court.
My lords, I bow down.
It's for the court to see
My lords,
whether.
what
See, it's like this, Mr. Paul. Now your prayer is confined to.
My lords, which is why I said
listen,
I am not.
Please listen. Please listen.
My lords.
It's confined to as what representing to the representation being decided that you file in 6/9/2024. Correct.
My lords.
In the intervening period, they file an affidavit showing what is the process that has been that has been taken till date, the inter-office memos or correspondence. So when they take a calculated or considered decision at that time, all these factors also will play a role.
No,
they cannot disregard even inter-office. They can't disregard.
If I may, I'm sorry to interject, my lords, if I may. Which is why, my lords, in the first instance, when my learned friend made that submission before my lords, that it is concerning the disposal of the representation, I said I am not in disagreement with him. I'm not in disagreement with him. Now, what I'm only saying is, my lords, that what is required of me to point out before your lordships is that during currency, my lords, they are not averse to what is being stated before my lords by the petitioners.
No, right.
That is what why I pointed out para 15, 16, and 20 is, well, is that they're not averse to this.
Yes, sir. The writ petitioners how many number?
Well, it's I'll just point out
77.
77.
The writ petitioner numbering 77 in number, who are serving currently as.
I am informed that some of them have retired also.
Lady supervisors. Well, some of them have demitted office in the meantime.
Who are serving or who are serving or were serving as
lady supervisors.
Lady supervisors are have come before this court, assailing the inaction of the state respondents in not affording promotion and not implementing the guidelines and rules issued by the Government of India.
So they are only for dispose of the representation, my lord. 6/9/2024.
Stop. The prayer
29
in the writ petition is for disposal of these grievances.
Where is this
the prayer in the prayer petition is for disposal of these grievances which are contained in a representation dated
6/9/2024.
Stop. In the course of the proceedings, the state respondents have since filed the affidavit where it is indicated, it is shown that certain steps and action have been taken in addressing.
Some discussions
some steps have been taken
for consideration
to address the grievances of the petitioner and to address the grievances as set forth by the petitioner. Stop. In this context, the senior counsel for the petitioners has also drawn the attention of the court to specific paragraphs showing this process that has been initiated. Stop. The Advocate General Advocate General submits that this court, without going to the merits of the matter, can perhaps, based on the prayer made in the petition, dispose of the matter by directing that the representation dated 6/9/2024 be disposed of within a certain time frame by taking consideration all the events that have transpired since the petitioners have raised their grievances. Stop. For having heard the counsel of the parties and in consideration of the Hundred of parties. It is therefore directed that the respondents shall dispose of representation dated 6/9/2024. That's annexure. Do you want to file any fresh representation or
not necessary?
That is annexures 4, my lord.
Annexure 4.
Yes.
And this will be by, my lord, state of respond number 3, my lord. Disposal will be by respond number
by the
3.
director.
Not director. Director is not competent authority, my lord. So again, they are getting favorable letters from director. So respond number 3, my lord. This state will be the competent authority. Secretary.
I will not see anything of the respondents.
Respond.
It's addressed. My representation is addressed. State, my lords, whoever.
State, my lord. State respondents.
That is your internal discussion.
Because internal director is writing to the director is not the competent authority. Government will dispose of it.
On the submissions of the council parties is therefore directed that the representation that 6/9/2024 be disposed to respondents preferably in a period of 3 months.
3 months.
But let it be 4 weeks.
By
4 weeks they will do it.
4 weeks, the Christmas vacation.
6 weeks. Let it be by 6 weeks.
6 weeks
they'll get the entire.
No. 8 weeks.
No.
8 weeks.
Let it be 8 weeks. Within 2 months.
My friend is
Let me 8 weeks.
Yeah, by 2 months.
By secretary
By
to
2
the
months.
government of Meghalaya, my lord, Department of Social Welfare.
No, by respondents within by 2 months from the date of his order. It is also
date of the order being communicated to the secretary, my lord.
Communicated to the secretary soon.
That's by my learned friend. I'm sorry, I'll not interject.
See, it becomes very difficult then.
I'm sorry. It's not the way.
Pramna. Within a period of 2 months, where date order presented before respondent number so and so. It's also made clear that whatever event have transpired after final petition as contained after it also be taken even due consideration when the representations disposed of.
By way of a speaking order.
And final orders passed thereof. Final order. You're not speaking.
He's speaking.
You have to be speaking. Yes. Like by ordered above. Petition of instances close dispose of. All other missed cases also. All police and close.
Good. Well, I must tender my apology for an expression that came out of me. Only reason is, Millets, that I said is once.
My friend got excited.
No, it's not. I did get excited. The fact of the matter remains, Millets, as a senior member of the bar, I must point out that when pleadings are there before the court, Millets, and when somebody's making a submission,
note of that and chosen to ignore it.
This is not the way, Millets. Once things are made, we can't make statements, ignore the affidavit.
Whatever you've said about the court, we've ignored it. Yes.
Well, I must tender my apologies, Millets. That was necessary. But it was in the context, Millets. It can't be. This court is a court of record, Millets. We have to.
I take the blame and I'm sorry.
No, it's not a question of blame. But
yes. Next matter.
23.
Yes.
There's a judgment passed by this court only.
Yes. This is more or less an issue regarding Millet's gratuity payable to a person Millet's who served for more than 30 years, and there is Millet's a judgment of this honorable court. Do we have an extra copy for the court? Please. One copy for madam. I'll just give you this. This is disposed of by judgment and order dated 14/6/24. See, this court. Well, it's para 10. If my lords can have a look at page 10, para 10. Just WPC 82 of 10. Yeah, just read para 10, Melits. The writ petitioner in this instant case was faced with a situation wherein the VRS application stood rejected, her regularization at the mercy of the respondents in spite of her long years of service, and with the impending elections which she was keen to contest in jeopardy, culminating in tendering her resignation. In this context, the case of so-and-so also comes to the assistance of the writ petitioner. The decision is relevant as it would be unthinkable to any employee having served for about 33 years to throw out the due benefits which would have been granted in the usual course, especially after the formal regularization order had been passed on so-and-so. Para 17 of the judgment is relevant, and my lords have reproduced the judgment bills. As such, in view of the peculiar facts and circumstances of the case, where the petitioner cannot be said to be totally at fault, the resignation of the petitioner shall be considered by the respondents to be in effect and in continuation of the application for voluntary retirement, and the petitioner consequently be afforded all the retirement benefits as entitled and permissible. It is further made clear the petitioner shall be allowed pension under the Meghalaya so-and-so rules. It is expected the orders in this regard be passed by the respondents at the earliest. So my lords have held, my lords, that once the period of qualifying service has already been met, my lords, resignation would not really come in the way. The facts of this case are, my lords.
The circumstances may be different.
My lords, in this case, it is absolutely similar, my lords. I'll just take your lordships to the facts of this particular case.
Yeah.
Well, as the petitioner, I was originally appointed as a lecturer in the Department of Economics, my lords, in Don Bosco College, Tura, and I joined my services on 16/3/1987. Do we have a copy of the list of dates?
Yes.
My services were regularized, my lords.
Yes.
We have a copy, just kindly give it to. Well, we have a, well, it's the relevant dates.
Yes.
Well, the service of the petitioner was regularized, approved with effect from the date of the college was brought on the deficit system, well, that is 17/1/1997.
Yes.
Well, I tendered my resignation, my lords, on 12/3/2018.
Yes.
Well, and that was accepted on 25/6/2018, Annexure 8, page 28, as your lordship would see, my lords. So 22/4/2021, my lords, I submitted an email claiming gratuity. The college is represented.
You ready the matter? Okay. Yes.
My lords, and your lordships may kindly come to the impugned order that you, my lords, would find that, my lords, this is order dated 27/3/2024 at Annexure 12, my lords, page 33. Well, it's page 33. 33 minutes.
Page 33. Yes.
Well, it's her claim for DCRG is regretted as per para 7D of the Meghalaya Aided College Employees DCRG Scheme 1985, which clearly stated that no gratuity shall be admissible to an employee who resigned from her services of her own volition. Now, I would have to take your lordships to the counters that have been filed, my lords. Counter of the state. This is state. The state, my lord, simply says, if I may just take your lordships to page 3. Paragraph 7, my lords, starts on page 2.
Page 3.
Page 2, my lords, last paragraph.
State affidavit.
My lords, state's affidavit by respondent number 3.
Page
2, my lords, last part.
Yeah.
A woman says so-and-so, the answering response states the petitioner in her own volition resigned from the post of assistant professor via her letter dated so-and-so. Resignation was duly accepted on 25/6/2018. With the acceptance of the resignation petition, the dual relationship between the employer and the state and the petitioner ceases to exist. The statement made by the petitioner, the termination of service by resignation tantamount to retirement by resignation, is baseless and unfounded claim. In cases of voluntary retirement, a claim for retirement pensionary benefits may be made. However, this is not the case. when an employee opts to resign from service as resignation entails forfeiture of past service. So this is the main issue, that whether my lord's resignation will entail forfeiture of past service. Indicate therein her acceptance of the resignation of the petitioner was communicated to her by so and so. Upon perusal of the said letter, it's clear the petitioner here had already secured appointment as associate professor in Amity University. Logical conclusion can be drawn from this is that petitioner resigned from her service in order to join her post as officer. Under Rule 6 of the Meghalaya Aided College Employees Death Cum Gratuity Retirement Scheme 1985 provides that an employee shall be eligible for death cum retirement gratuity on her retirement on date, while Rule 7 provides that no gratuity shall be admissible to an employee who resigns from the service of their own volition. It is pertinent to state herein that as per so-and-so, the rules do not apply to persons who are entitled to the benefit of contributory provident fund. Therefore, the aforesaid rule shall not apply to the petitioner herein, as she subscribes only to the contributory provident fund. So this is the plea that is taken by the state, Milits. And so far as the college is concerned, Milits,
yes, what does the college say?
Para 8 would be relevant, Milits. That in light of the clear and unambiguous language of Rule 7D of the scheme, the petitioner is barred from claiming gratuity as a resignation amounts to voluntary termination of service. The petitioner's case therefore falls squarely within the purview of the aforementioned provision, which expressly denies gratuity benefits to any employee who resigns of her own volition. The petitioner having resigned cannot be equated to an employee who has voluntarily retired.
Yes. Yes, Ms.
May it please, Your Lordship.
Yes.
Your Lordship, we are relying on clause 7D of the Meghalaya Aided College Employees Death Cum Retirement Gratuity Scheme, Your Lordship.
But I think there's an appeal against this order, Mr. Paul.
I'm not aware
Your
of
Lordship,
this.
and I'm also in this case, Your Lordship, I try to draw. I'm drawing a distinction between what my friend, because theirs was a case of voluntary retirement.
No, this case, what happened?
And here is a clear case
I
of
would try to balance equities because
Yes.
the petitioner was made to run from pillar to post. You were granting a VRS. You wanted to contest.
Yes,
elections,
she wanted, and so she.
and she lost her
resigned from
service. She lost the elections. She should not.
So she was more or less compelled to retire.
Just find out.
7D
But
would
there
happen.
is a-
My only
just find out what happened there.
We'll find out regarding what is this. My entire case is on the basis of this is the Meghalaya Aided School Employees Death Cum Gratuity Rules
Court did
1985.
not interfere in the
Now it
appeal.
says two things, which are relevant for the purposes of this particular matter. It says, qualifying service is defined under the Act, under this Act, It says, qualifying service means service rendered while on duty or otherwise, which should be taken into account for the purposes of gratuity as admissible. And then commencement of qualifying service is again defined, and certain period is only mentioned for the purposes of qualifying service. So what we are humbly submitting before your lordships is, as long as I have met the period of qualifying service, if post the qualifying service I resign, or
how can you jump the hurdle of resigning own volition?
Yes, Your Lordship. Your Lordship,
That
in
is-
fact, she had taken lane for a period of 1 year, and then she submitted resignation on 12th March 2018, Your Lordship. And the language is very clear, Your Lordship. I hereby render my resignation from the post of Associate Professor, HOD. There was no compelling reason for her to resign, Your Lordship, like in the other case.
I admit that it is on my own volition.
Yes, then you have forfeited all the past services. in
Because
view of the
Rule 5.
Rule 7D of.
Anyway, we'll get back to your lordships with the status of this.
We'll have it
particular
next
matter.
week or after vacation.
Let it come up after vacations, because under the rules, it says that 5 years is the qualifying service. So if there's 5 years qualifying service,
Yes, after some.
In this, and
On
we have
the
got,
parties list the matter of first vacation for final hearings.
after the victim.
It is upheld.
No, it was dismissed.
There was an appeal apparently. They've taken out. There was an appeal, but that has been dismissed. My lord's order has been upheld. We'll bring it on record,
Well, we have to be clear.
Yes.
What does the
Under what-
judgment
Under what-
bench say?
The-
It might have.
Facts and circumstances are different, Your Lordship.
Obliged.
Obliged, Your Lordship.
27.
sir? What is this?
Any PM.
Have you filed? Affidavits have been filed?
Lordship, I'm praying for some accommodation.
Complete.
No, have affidavits been filed?
Pleadings are complete.
In fact,
no, have affidavits been exchanged?
Pleadings are complete.
Yes, sir.
We come out of vacation, sir.
Yeah, for the union.
Yes, Lordship.
Yes, MS Sijala Vice, Dr. N. Muzika, raised that the matter be fixed after vacations, not objected to by senior counsel this after vacations.
Obliged.
31.
Here also pleadings are complete. This may also come up after the vacations, my lord. It'll take a long time because we'll have to make a compilation of the judgments as well.
Which one? What is this case about?
It's
regarding the.
It's where the scheduled caste category people and scheduled tribes have been put together for joint competition. They've been clubbed together.
Okay, by the state.
Yes, ma'am.
After vacation?
Yes,
Come
ma'am.
out after vacation.
Yes, on the pre and counsel of the party, this matter of vacation. Yes. Hello.
Obliged.